A very hearty good evening to all of you. In the last class, we have started the concept of alienation. The third topic of your module 2 talks about the alienation of co-personary property. So we all know that regarding separate property, there are no issues. I hope that in the last lecture, your doubt has now been cleared regarding the uh, alienation of separate property, which is done by the Transfer of Property Act. Now further we have to see further we have to check the alienation. So we have started what is meant by the term alienation. Where alienation means transfer of property, and transfer of property are having many modes. For example, gift, sales, mortgage, and alienation have added importance to the Hindu law. As ordinarily neither the Karta nor any other co-partner singly we can say possess the full power of alienation over the joint family property or over his interest in the joint family property. Though under the Dayabhaga school, a co-partner is having the right of alienation over his interest in the joint family property. So we are not concerned with the alienation of a separate property because, as we have discussed in the last lecture itself, that every Hindu, whether governed by Mitakshara school or any of the sub-schools of the Mitakshara law or the Dayabhaga school, they are having the full power and we can say that the absolute powers rather of alienation, and such alienations are governed by the Transfer of Property Act. So this is the basic difference which we can say that how the properties are governed and what are the differences. So further we will discuss the subject under the following hats. The very first is the father power of alienation. We have started in the last class regarding the father power of alienation. We will also see Karta's power of alienation, and this time we will go in detail. We will try to analyze the things with the help of case laws. Third is the co-partner's power of alienation, which again we will be discussing with the help of case laws. Further, we will be seeing the sole surviving co-partner's power of alienation, alienee rights and remedies. So these are the, we can say this is the sort of an outline of what we have to see under the third topic, co-partnership property alienation, the alienation of co-partnership property. So further, I'm moving to the next slide, which is talking about the father's power of alienation. So we can say at one point of time, a court used to have you can say conflicting view regarding the father's power of alienation over his separate property. But now we can say the father is having full power of disposal of his separate property. The reason behind this conflict was a text under the Mitakshara, according to which the father is subject to the control of his sons and rest in regard to the immovable property. So these are the conflicting views which are there regarding the father's power of alienation. So this particular issue was solved by the Privy Council, the case known as Rao Balwant Singh versus Rani Kishore. And this particular case, the Privy Council propounded the principle in the year 1898, which is a very old case, in which the Privy Council said that set at rest to the controversy which was going on regarding the conflicting views of father's power of alienation, and it was held that father has full power of alienation over his separate property, both movable and immovable. So the text of Mitakshara was overruled, and the Privy Council stood and said that Mr. The father is having the full right of alienation of the property. And also, it was held that the separate property which a person is doing, he is not bound to ask the permission. He's not. There are no such bars over it. So it has. We can say that it has been all along recognized that the Dayabhaga father is having full power of alienation over all the properties, whether they are self-acquired or ancestral. So Dayabhaga's school from time, we can say, a very beginning, it was supporting the claim that a father is having a right to alienate his separate property. And Dayabhaga school provides full power of alienation over all the properties, whether they are self-acquired or ancestral property. So the concept of succession or inheritance, as we have already discussed in detail regarding the Dayabhaga school, I am not going in detail again. You may refer to my previous lectures in which we have discussed the difference between Mitakshara school and Dayabhaga school, and under which we have dealt in detail regarding the differences. So when we talk about the Mitakshara school, we see that Vijayaneshwara sought to impose restrictions on father's power of alienation over his self-acquired immovable property. On the other, he sought to give him wider power over ancestral movable properties. However, it is not a settled law, okay, that the Mitakshara father has no great power over the joint family property. We can say that then over the joint family immovable properties. Only power of father that has survived is the power of making gift of love and affection. This is something which has survived. Another power of father has been created by judicial decisions and the power of alienating joint family property for discharging his personal debts. The father Karta has the following two special powers which we will be discussing in detail. The gift of love and affection, or we can say the alienation for discharge of his personal debts. So, when we talk about the gifts of love and affection, we have to understand that the father is having the power to make a gift of love and affection of a small portion of a movable joint family property. So, Mitakshara School of Law discuss the same thing, and also in the case of Tejnath versus Commissioner of Income Tax, the same thing has been, we can say, the same principle has been propounded regarding the father's power of alienation, and it was said that in this particular case, okay, so in this particular case, it was held that the gift of love and affection of a small portion of a movable property, the father is having the power to make it. That property belongs to the joint family property. We can also say that such gifts which may be made by him to his own wife, daughter, son-in-law, son, daughter-in-law, or to any near relation. So these may consist of jewelries or jewelries made of gold or silver, or rather clothing, cash, or any movable property. Such gifts are very common. You can say such gifts are very common, and among, we can say, the Hindus, and are ordinarily made on, we can say, some occasions. There are very special occasions where the gifts are being given by the father on his own, we can say, by on his own free will. The father possesses the power of providing the gifts. The father is in a position to provide the gifts, and therefore this particular thing is there. There are so many occasions. For example, apart from marriages, also there are so many religious ceremonies which happens in a house, and therefore the father is having those, we can say, parts of making of the alienation. Okay, so further we can say uh, uh, that that there are ceremonies like Mundana which happens, and or when the daughter after marriage visit the house of the father. So when a child is born to her, and if the child is a male child, a gift of love and affection are usually of higher value. A gift of love and affection may also be given to daughter-in-law when she gives birth to a child. So there are many, we can say, cases in which the father is a person who provides to, who is made responsible for a gift, and that is the case of, we can say, under the love and affection, and we are covering the case of movable property. A gift of love and affection may also be given, we can say, under to other people also. Apart from that, there are certain conditions, and there are two necessary conditions for the validity of such gifts. The very first is that it should be a gift of love and affection. The father should stand in some relationship of affection to the donee, and the gift should be, we can say, a small portion of movable joint family property. What is a small portion is a relative term and has to be considered in relation to the entire joint family property. So whatever joint family is there, they will decide further what is meant by the term small portion. And when we talk about the gifts of immovable property, this one, okay. Although there is a rule that such gifts cannot be made of immovable property. But in the case of Brahma versus Malappa, a gift of immovable property to daughter made by the father after her marriage was held valid. In this particular case, it was held that whatever father gives to her daughter, the gift of, we can say, immovable property, which is made by the father after her marriage, that particular gift was held valid. The Supreme Court justified such gifts, and also by saying that it was given in view of daughter's share in partition. So this was the concept, we can say, this was the theory which was propounded by the Apex Code, and the Apex Code rationalized this particular immovable property gift by saying that it is the share of the daughter. It is a share of a daughter which is given in view of shares which she is owing, or whatever she will be getting after partition, and which is recognized by the old ancient law. It is submitted that despite this particular reasoning, gifts of love and affection of immovable property cannot be made to sons, for that matter to any member of joint family property. The Supreme Court, we can say that, in a case known as uh, Nature versus Jaya Raman, Nature versus Jaya Raman, Nature versus Jaya Raman. In this particular case, the Supreme Court has held a decision and has confined the rule that gifts of daughters. So thus, we can say a gift of love and affection of immovable property cannot be given to anyone else, not even to wife or daughter-in-law. So the Supreme Court in this particular case has confined the rule to gifts of, we can say, of daughters. Now we will be moving to the next slide, and we will try to analyze the other important issue. So when we talk about the Karta's power of alienation, Karka's power of alienation, although we have dealt in detail, but still there are many aspects of Karka's power of alienation which needs to be answered. And what I suppose that we should try to answer them with the help of case laws. So first, we have seen an outline of what is meant by the Karka's power of alienation. I suppose in 13th or 12th lecture of mine, you may refer to it. Although no individual co-pastor, including the Karta, has any power to dispose of the joint family property without the consent of all others. Okay, so no individual co-pastor is there who's having the power, including the Karta. Mr. Karta is also you can say, no position to dispose of any joint family property without the consent of the other members. It is recognized by the Dharam Shastra. There are certain circumstances. Any member of the joint family has power to alienate the joint family property. And we can say the Mipakshara is explicit under this on this particular matter, and Vijayaneshwara also talks about that even one person who is capable may, whatever he says, that Vijayaneshwara is having an opinion that every person who is having the riots, he is in a position to make or make a gift or sale of immovable property. So Vijay Neshwara is having the opinion, and according to his opinion, we can say that the persons are having the power to make a gift if a calamity is there. We talk about we have seen in detail what is meant by the term calamity, and there are instances which we can say that which affects the whole family, and uh, or we can say that there are situations in which that we can say the karta has to provide the support to the family, and which is necessary or indispensable duty, such as we can say the fathers or the life which they try to, which is very unavoidable. Under such circumstances, there are certain we can say situations. But Janeshwara has also recognized that there are three situations. So all the three situations we have dealt in detail, if you are able to recall. So we have seen that there are certain exceptional cases, and under those exceptional cases, the alienation of joint family property could be made. And when we talk about the alienation, we all know that we know that in the time of distress, which is known as a sort of a legal necessity, also we know that if for the sake of family, whenever it is necessary. And according to Vijayaneshwara, it seems that Vijayaneshwara did not purport to assign this meaning, but what he has done that he has said that for the maintenance of the members of the family under such situation also. And then we are having the indispensable duties, which we have already discussed in detail. So there are certain exceptions under which Karta is having the Karta is having the power of alienation, and Vijayaneshwara, we can say that conferred this power on every member. So there are different members, and every member, according to Vijayaneshwara, is having certain powers. Uh, every member of we can say of the family under the circumstances which we have discussed, and according to which the formulation of Vijayaneshwara has we can say according to the passing of time has undergone modification, and generally in two respects. And the very first is that the power cannot be exercised by any member except the karta. So whatever Vijayaneshwara was having, that the other members are also having the power to alienate the property under certain special circumstances, which is the time of distress, or we can say that for the sake of the family or for the performance of indispensable duties. This particular thing has been, we can say, but the passing of time has been modified, and further it is held that the power cannot be exercised by any member except the Karta. Mr. Karta is in position. Secondly, we can say the joint family can be alienated for the various purposes. Now, this purposes has been, we can say, classified as a legal necessity, which we have seen in the last class. Also, we have seen that we have already discussed three important necessities which are there. And when we talk about this, the very first is the legal necessity, which is very much similar what Vijay Neshwara has said for the sake of family, or for the time of distress, which he has laid emphasis on. And this legal necessity is something which is very close to the concept of Vijay Neshwara's concept of apatkale. Okay, as well as the one which is Kutuma Bharte for the sake of family members. And the second one is the benefit of state. Again, this benefit of state which he talks about, this benefit of state, we can say is including the other parts of Kutum Bharte for the sake of family. And third, which we will be seeing is indispensable duties. This includes the entire head for, or we can say, now this we can say it is certain that Karta can alienate the joint family property with the consent of the co-partner, even if no co-partner above, if even we can say if none of the above exceptional cases exist, we can say that okay, if all the co-partners are adult, it is binding on the entire joint family. So these are certain things which we will be discussing regarding the Karta's part, and there are we can say as I have rightly discussed with you that the settled law is that a karta can alienate the joint family property with the consent of co-partners. Okay, and if none of the above exception cases exist, then if all the co-partners are adult, it is binding on the entire joint family, because we know that whatever contract is being made by the karta, that contract is binding. It is having a binding effect, and therefore the excuse me, all the family members are, we can say, are having a liability towards such contracts or such, we can say, agreements which are being made by the karta. And if once, we can say, if only some co-partners consent, then in Bombay and Madras it will be binding on the interest of consenting co-partners. But in West Bengal and Uttar Pradesh, the alienation will not be valid. So when the some co-partners have given their consent, so it is okay under Bombay and Madras school, or under the territory of Bombay and Madras. But it will be, we can say, on the interest of, in the interest of the others consenting co-partners. But when we discuss about the situation prevailing in West Bengal and Uttar Pradesh, the alienation will not be valid. But an alienation without the consent of co-partner, which is not for a legal necessity, is altogether void, which we have already discussed in our last in the 13th or 14th lecture, when we were discussing the powers of karta. So these are certain situations which, as a student of law, you should remember that what are their implications and how they are producing an effect. Further, when we move towards the Privy Council also, we try to check the Privy Council in a series of cases. It was held that when Karta exercise power of alienation in certain, in some exceptional cases, the consent of other co-partners will be implied. So Privy Council have also propounded that, in we can say, in ample of cases, that the karta power of alienation, in exceptional cases, the consent of other co-partners will be implied. So it will be assumed that the other co-partners has accepted whatever karta has done. So since then, it is accepted that the basis of karta's power of alienation is implied consent of the co-partners. This concept also we have studied in detail when we have gone to, when we are checking, um, the powers of the karta. Okay, if you are able to recall, at that particular point of time also, I mentioned you the same thing, that whatever contracts and agreements which are entered to them, the karta is a person who is also made responsible. Then further, the karta's alienation in the aforesaid cases bind the interest of the minor co-partner also. So there are certain cases of alienation, in which the interest of minor co-partner is also binded. Although for compromise we require the rulings of Order 32 of Civil Procedure Code, where the compromise for, we can say, for a minor will be made in the presence of court. But whenever a contract has been made, or we can say that, whenever the karta exercises power of alienation, the consent of other co-partner is deemed to be implied. It is assumed that they have given their consent, and on this particular basis also the minor co-partner's interest is also, we can say, binds the interest which has been created by the karta's power of alienation. But there is a difference between compromise, which is discussed under the Order 32 of Civil Procedure Code, which we have already discussed. Okay, whenever a karta is doing, on behalf of a minor, a compromise, so uh, the compromise has to be done in front of the court of law. Okay, that was discussed under Order 32. So this situation is different. Here it is talking about the interest. Okay, don't get confused. So we can say that the current basis of Karta's power seems to be the authority and inherent in his position as a Karta. So as a particular person becomes a Karta, there are so many powers which he gets, we can say, automatically he is in the position to exercise his power, and one of those particular powers is power of alienation. And further, we can say that this particular power of alienation also been recognized by the ancient Hindu texts and the modern judicial pronouncements also, which are there and extending a period of 100 years, and it is not implies consent of the co-partners. So this particular practice is, we can say, has been cherished by not only by the Hindu text but also by various judicial pronouncement which happened starting from the Privy Council till date. So there is a, we can say, there is so much precedent available. There is so much support and rationality available for the Karta's power of, we can say, alienation. So I hope that this particular concept is clear to you. Now we are moving towards section 6 of Hindu Succession Act, and we will be trying to correlate it with the alienation. So when we talk about what is meant by the implication of section 6 of Hindu Succession Act, what if a co-partner dies, leaving behind an heir in terms of the proviso of section 6 of Hindu Succession Act. Uh, Further, can the Karta alienate the female's share in the co-pastory property? So the question arises here whether the Karta can alienate the female share in the co-pastory property. So, what has happened after the, we can say, what if we try to correlate with section 6 of the Hindu Succession Act, we can say the female share in the co-pastory property which has got vested in her on succession. Okay, so when the succession has completed, now the female is having certain, we can say she is holding certain property, and what will happen to this particular property which she is holding? So it seems that he cannot do so. The Karta is in no position to alienate the property which a Hindu female got after the succession. Okay, so Karta is having no right over her property without her consent, because the property which is acquired under section 6 is now a separate property. So you have to understand the concept of the separate property. As soon as any property, we can say, moves from the joint family property or ancestral property to the domain of separate property, then that particular property belongs to the person to whom the property has been transferred. Okay, this is the concept. Wait for a few moments. I would like to drink some water. Okay, excuse me. Now, when we talk about the concept of legal necessity has not been defined very clearly. Okay, and if you try to provide a possible definition, again, it would be very difficult for us to provide a very precise definition, because the case of legal necessity can be so numerous. As I have discussed with you, I am not going to detail again. If you are, please refer to my lecture in which I have discussed with you the Karta's power of alienation. So there were 10 powers of alienation which we have discussed in length, if you are able to recall them. Okay, and this was one power. Now we are looking to this thing with a different view. We are dealing with alienation of a co-partnership property. And here also the Karta's power of alienation is reflected. So please don't get confused. There we are talking or discussing Karta's power. Okay, the powers of Karta. Here we are talking about the alienation of co-partnership property. So first we have seen the father's power of alienation. Now we are looking at the Karta's power of alienation. Okay, so please don't get confused. And when now we are discussing the Karta's power of alienation, again we are seeing the same thing, that Karta is in no position to alienate any property, except we can say there are certain situations, certain conditions, and those conditions are, as we have discussed, legal necessity, benefit of the state, and indispensable duties, acts of indispensable duties. Now, further we are moving towards this particular term, which is very vague, we can say, and also this particular term, broadly speaking, will include all those things which are deemed necessary. Okay, so anything which is deemed necessary will fall in the, we can say, under the broad domain of legal necessity. Okay, and when we talk about the members of the family, the term which was used by Vijayaneshwara, which is apat kale, those people who understand Hindi, they will understand this particular apat kale. Apat means emergency, and kal means time. So whatever emergency of the time is, okay, may indicate that the joint family, if suppose there are earthquakes, floods, and whatever natural calamities are there, so this particular power can be used. Okay, famine is there, epidemic is there, pandemic is there, whatever. Okay, and alienation in such circumstances will be undoubtedly, we can say, valid. But it would not be right to say that alienation can be made only in times of distress. Okay, it is now established that the necessity which is there, and that particular necessity is very, we can say, crucial to establish. Okay, so further we can say that the necessity has to be established if the karta is trying to alienate the property. Also, that the necessity is not to be understood in the sense of what is absolutely indispensable. And so, this particular thing, we can say, was discussed further in the case of Rani Shanta. In this particular case, Rani versus Shanta, that to establish necessity, it is not to be understood in the sense of what is absolutely indispensable, but what, according to the notions of Hindu family, would be regarded as proper and reasonable. You are we won't judge the term legal necessity. We can say that it is very absolute and indispensable, but we have to check the notions of the Hindu family, the notions of any family under which a legal necessity has to be made. And we can say that whether it will be regarded as proper and reasonable or not. If it is not proper or reasonable with the notions of the family, then it won't be legal necessity. And this was discussed in the case of Rani versus Shanta by the Honorable Supreme Court of India in the year 1971. Okay, so this case is very crucial in terms of deciding that what is proper and what is reasonable to any joint, we can say, to any joint family. Also, the actual compelling necessity is not the sole test of the validity. So we can infer that the actual compelling necessity is not a sole test of the validity of alienation which is made by Karta. Okay. So now in the case of Krishna Das versus Nathuram, the second case, in the second case, we can say that we can conclude that legal necessity does not mean actual compulsion. Legal necessity does not mean the actual compulsion, it means pressure upon the state, which in law may be regarded as serious and sufficient. So, in this case, it was discussed that legal necessity does not mean actual compulsion. It is not something which is compelling a sort of which is compelling the alienation, but it but it means a sort of a pressure upon the state, which in law would be regarded as serious and sufficient. And therefore, this particular thing has been discussed in a different, we can say, in a different sense altogether. Okay, in the case of Krishna Das versus Ram Vilas. Now moving to this case of Ram Vilas versus Ramanand, it was held that the term has to be interpreted with due regard to the conditions of modern life. So whenever we have to discuss the term of legal necessity, maybe Vijayan Rishwara was not able to define the modern day, we can say, modern day circumstances or the modern day problems. So whenever we have to interpret, we have to consider the issues of modern day life. It is very crucial. Also, we can say that further moving to the case of Arakkal versus Arakkal. In this further case, we can say that, however, whenever there is no proof that the business is a family business, any loan taken for a business by the Karta cannot be said to be binding necessity or for the benefit of the state. Okay, when there is no proof that the business is the family business, and whichever loan is being taken by for a business by the Karta, it cannot be said that it is something which is binding on the benefit of the state. So these are the certain terms, and further we can say that in the case of Rulia versus Jagdish, it was held that Purulia versus Jagdish are sort of, we can say, the innovations of the case of legal necessity cannot be exhaustive. You can't just create a watertight compartment to define the, we can say, the term legal necessity. We have to note that there are certain, we can say, there are so many illustrative cases which falls under the category of legal necessity. Maybe it is related with food, clothing, shelter for the members, marriage, the members of the family, including daughters, and so on. So these are the things which we can say are having the term legal necessity is, we can say, uh, cannot be enumerated, and because legal necessity is a sort of a term which is quite we can say it is not so broad, it cannot be very exhaustive. It has to be something by which uh, the karta is able to decide that this particular thing fall under the category of legal necessity. Maybe it is related to food, clothing, shelter, or it is somewhere related with marriages of the family members, or which we can say towards whom the karta is having a special duty. Now, further, we will be discussing this particular case of Patel. Patel versus Lakib Reddy. Okay, so the Madras High Court took the view that second marriage of a member is not a legal necessity. The second marriage of any family member is not a legal necessity. Although we have seen that marriage falls under the category of legal necessity. So there are disputes among there are family feuds among the family property or family, we can say joint family, and it becomes difficult for the court. Time and again, I have told you that, see, whatever you see, whatever you see the judgment of the Honorable Supreme Court or High Court never took them, we can, what I can say, for as a, we can say, word of God. Okay, they may get changed. The interpretation may get changed. It is not that you are having the chemical formula of any element which will be immemorial and which is universal, which is having the same H2O value from China to Europe. It is not so. We are dealing with law. It is a subjective term. It is in the case of Patel versus Lucky Reddy. It was held that second marriage is not something which falls under the category of legal necessity. Then again, it is subjective, and it may get changed that the second marriage of a member is not a legal necessity. But it was held in this case. We are studying law. We are trying to analyze. If suppose what we are not discussing the facts of every case. If we go to the facts, we would find that whoever was pleading, whoever was the advocate, he or she was able to persuade the court, and therefore the court propounded this particular principle. Okay, so further we can say that there are ample of cases where we can say that even the Nagpur High Court has held that the marriage of a daughter's daughter, or when the daughter is not indigent, is not a legal necessity. So there are so many cases I can go on propounding. I can go on just telling you the cases, and we can do a dissertation of masters. Okay, but right now, short-term object is to clear the exam. If you are able to remember out of whatever cases, we can see 6 cases I have discussed with you under the heading of legal necessity. If you are able to write or record even 3 or 4 cases, it will suffice your cause, because you will be answering a question which is having 3 parts. Benefit of the state is there, indispensable duties are there, and legal necessities are there. So you have to understand that case laws, if you are writing 3 case laws, and then further you are just trying to refer to a case law that it was held in the Nagpur High Court in a very, we can say, in a case, or it was held in it was held by the Madras High Court, then according to me, if your answer sheets are coming, you are lucky enough, I will consider them, because I will understand that these are the cases you have gone through, and being a student, it is not possible for you to remember each and every case. Okay, so this should be your approach while you are trying to answer any case, answer any what we what answer any answer. Okay, okay. So Nagpur High Court also has a view that daughters marriage is also not a legal necessity. Further, we can say that marriage of a minor in violation of child marriage is also has been taken that it is not which is restrained by the Child Marriage Act 1929 and unlawful against the public policy. It was held that it is not again a legal necessity. So medical care of the family members, defense of the members involved in serious criminal charges, but not for the prosecution of a member accused of murdering a member of the family. If suppose a family member murders another member of a family, this was held in the case of Marulappan versus Mirakulappan. So Marulappan, Marulappan versus NIRAIKKULLATHAN. So in this particular case, it was again held that whenever there is a criminal charge, and a criminal charge that a person has been accused murdering a member of the family, then that particular thing again won't fall under the category of legal necessity, and it won't suffice the cause of a alienation of a joint family property. So there are different, we can say, instances which a student of law should understand, the student of law should recognize, and how the property will get, we can say, alienated. Further, we can say the for the payments of debts, for the payments of debts, for the payments of government dues. These are the conditions which we can say that which creates a force of alienation under the heading of legal necessity. Also, whenever there is a issue of revenue or income tax, or for the performance of necessary ceremonies. Okay, we all know that there are so many ceremonies which happens after a particular person has died, which is known as shad and all those things, for the payment of rent, sale of land to the construct, or rather the construction of a pakka house, alienation by the karta to purchase agriculture implementation, where the family has been engaged in agriculture. They are all forming the part of legal necessity. Whenever the karta is going to purchase any tractor, any agriculture, we can say a tool, or any agriculture machine, moped, whatever, so they may fall under the category of legal necessity. So the category of legal necessity again, which I can conclude is that whatever has been said, that the enumeration of cases of legal necessity cannot be exhaustive. We are not in a position to pen down all the things time and again. It is not possible to pen down each and everything, because each situation is different, each circumstances is different, and therefore the inference which would be drawn will be different. So what I have tried to give you a I have tried to provide you a understanding by which you will apply your mind itself to infer further things which will fall under the category of legal necessities, and which was happened in the case of Ram Vilas versus Ramanand, and that was a very, we can say, important case in terms of talking that alienation for satisfaction of need, whatever is there, it should be interpreted to due regard to the conditions of modern life. Okay, so this is what we have to understand, that whenever we are going for the alienation should be interpreted legal necessity rather with due regard to the conditions of modern life. Whatever modern life conditions are there, and by inferring those conditions, Karta may go for alienation. So what will happen when the family members are having no issue, and that particular alienation which was made under the head of, we can say, legal necessity, and family members are having no issue, it is okay. But suppose Karta made something under the legal necessity, and we all know that everything can't be defined. It is a very, we can't have a precise definition. We are dealing with law. We are not dealing with. We are dealing with a part of social science. Okay, so anything can be a bangle. It may be of plastic, it may be of glass. So we are dealing with a particular subject which is having the influence of geopolitics, which is having the influence of society. Society is at one point of time is trying to transform the law, and also there is a pushback when the law is trying, when the society is trying to transform the law, and when the law is trying to transform the society. So we can say it is a sort of a thing which is happening both the ways. So what happened? Karta has done an act under assuming that this is what legal necessity, and further what happened after some time, it got challenged in the court of law, and the court is not satisfied. So neither Karta should be blamed nor the particular members who accepted the consent, because it is a concept, we can say, which is subjective. This is what you have to understand whenever you are interpreting the law. That whatever has been said, it is not a revelation of the Almighty. There are things it may get changed. Okay, so I am ending here, and I hope that this particular concept is clear to you. And further, in the next class, we may start the benefit of state, and we may see the acts of indispensable duty. I try to bring all the important aspects of legal necessities and the father's part of, we can say, alienation, so that you are in a position to write it. Okay, so thanks for your patient hearing. Hope we will be meeting in the next class. Till then, have a good day, have a good time.